versus State. It's 303 Georgia. 496, it's in Division 4. 813 Southeast 2D 360, 2018. That case is a pre-January 1, 2013 trial. So the self-serving statement objection was valid. So that's why I put that case in the motion. And then it's a good case of Hodges, which it's State actually versus Hodges, Hodges, 291-413, footnote 6, 728 Southeast 2D 582, 2012. Obviously, that's before January 1, 2013. But what happened was our Supreme Court said that the new evidence code has indoctrinated or codified, I guess, OCGA section 24-8-801C, and that the new evidence code would not retain the self-serving statement rule. And instead, the court looks at relevance 401, 402, and then obviously 403 is for everything. In federal courts, United States versus Jackson, JCKSON, 780 F2D, 1305, it's 7th Circuit, 1986. For over 40 years, self-serving rule was not followed in federal courts. And here, what was happening is anything said by Mr. Williams that I tried to get in on cross-examination would be met with an objection that was sustained as self-serving statements. At times, the recused Judge Glanville would allow it in under the rule of completeness, so 106 and 822, or 24-1-106 and 24-1-822. There were times that he let in, but self-serving statements were excluded, even though they weren't going to innocence, which under the old rule, self-serving statement has to go to innocence. That's why it's self-serving. But anyway, I'm not saying that it's ever going to come up, but it happens so frequently. I just wanted to be courteous because that's the way it was going for several months in the court. So I just wanted to raise that to your attention. That's really what it is. In paragraph 11 of that motion, Your Honor, there was not as much, but under, I think it's 24-8-801. You got, I'm looking, my computer, 2B. I'm not sure that's right, but I think it's 2B. It deals with a statement that's adopted. So Judge Glanville would allow in, well, this was sent on social media and your client didn't respond. Oh no, that's not accurate. Or there was an alleged meeting and your client was there and he didn't deny it. Or somebody else had a lyric in a musical song and your client didn't come back with the next verse and say, oh no, that doesn't apply. And that's not an adoption has to be specifically intended to adopt by your silence. Like, so anyway, those are my issues.
Okay.
They came up a lot. I'm not, Your Honor, I am not saying that there'll be issues going forward, but it like permeated this trial.
Okay. I appreciate you bringing all of that to my attention. And I mean, this isn't really, I guess this is more bringing it to my attention than anything else.
Yeah.
We're not talking about anything specifically right now. And obviously, as we're moving forward, we'll take up specifics of things as I'm going to say as we get to them, although if there's evidence that either side knows they're going to be intending to use that might have issues or objections, let's try to deal with that to the extent we can before we're in front of the jury. I think I said that already. But, you know, I looked at all your case law and I've looked at the statute and I don't know whether maybe some people were just using self-serving as sort of shorthand for something. I don't know, but I agree that there is not that's really no longer the issue. And if something is going to be excluded, it's not going to be on the basis that it's self-serving. It's going to be on the basis that it's hearsay and there's no recognized codified exception that has been met. So, I mean, that'll be my intention going forward is, to look and see, is it hearsay? And then if it is, and obviously a prior statement of your client is probably going to be hearsay unless and until he testifies. So the question is going to be, does it come in under an exception? Is it a prior consistent or a prior inconsistent statement? And with regard to adoptive admissions as well, I agree. There has to be something to indicate, not just I heard it and I didn't say no. It has to be I heard it and I didn't in some way dispute it when the circumstances would expect me to dispute it. So yeah, generally speaking, that's my understanding. And like I say, we'll take up the specifics as they come at us.
Thank you, Your Honor.
All right,
That was the totality of that.
great. Thank you.
This is left. Can I ask a question?
Yes.
There's I don't want to take something, but there's a transcript of the January 10th, 2024. That's yours?
Yes.
Okay, I just want to make sure.
I don't know. I think I handed yours back to you before.
Okay.
So I handed, or through my staff attorney, handed you back your copy. I don't know what that is. Okay, understood. All right. The state has a motion to exclude victim character evidence. It was filed on July 23rd, and I don't know if that's something that has been ruled on previously or what this one is really. Has that already been dealt with, or where are we on that?
It has come up, Your Honor, ADA action on behalf of the state. The state wanted to file that for the court's guidance of any motions where we were going through specifically Mr. Copeland's redactions.
Okay.
And there was a couple times, and Judge Glanville overruled the state's objection. We wanted some what we classified as speculative homicides that the deceased victim, Mr. Thomas, was involved in, that Mr. Copeland speaks about in his interviews.
Okay.
And so those redaction conversations with the court were after June 12th. So the state, foreseeing and forecasting at least that specific issue and or additional questions that may come up, wanted to file this motion precluding improper victim character
Okay.
evidence, Your Honor.
And flesh it out a little bit more for me.
Yes, Your Honor.
So Mr. Copeland wanted to testify to, and or you all had prior statements where he had mentioned and you wanted to get in him saying something about homicides that Mr. Thomas had been involved in perpetrating
So, Your Honor,
potentially?
yes, Your Honor. And I have some, let me draft these notes right here.
Okay.
Oh, no, no. I wanted to show these examples. So, Your Honor, I printed some examples where Mr.
Okay.
Copeland, this was what the state wanted to keep out. So,
Wanted to keep out.
yes, Your Honor.
Okay.
And the way that the Honorable Chief Judge Glanville addressed these redactions was, state, let me know what you're not playing. And
Right.
then defense counsel would bring up questions they were going to ask Mr.
Okay.
Copeland and or play. So there was portions the state was not going to play and defense counsel said they wanted to get into, where
Okay.
Mr. Copeland is mentioning there's a murder on Auburn Avenue. There's an individual by the name of Scooter. And it comes up kind of off the cuff of he heard that Nutt had something to do with this murder. And so the state felt that that falls under what's kind of classically a specific bad act of a victim, which can't come in under really any witness to include a deceased victim in a case. And the case law and the state's motion on that is, explains all of that, I feel like, succinctly. And so the state, knowing that we're going to have to go back over these interviews with Mr. Copeland,
Okay.
and some of this may depend on the questions asked and his responses, the state filed this motion. There may be other instances. Those are what came to mind because we recently addressed those. And they're in a recorded statement of Mr. Copeland that the state did not want to play, but defense counsel wanted to ask Mr. Copeland about and or play it if it was impeachment.
Under what basis, if y'all had gotten that far, and maybe it's more fair to ask the defense.
I was
under
gonna
what
say that, Your
basis,
Honor.
But,
I will defer to the defense on their basis for that because I don't want to misspeak
Okay.
for them.
all right. Somebody from the defense want to let me know what they might intend to argue with regard to this type of evidence?
Couple things. First of all, regarding Mr. Thomas's character in general, the state, and I defer to the recordings. I don't have it in front of me. I'm not intentionally misspeaking. My recollection is Miss Love indicated on January 10, 2015, Mr. Thomas was just hanging out, on the street with his good friends, having a good time and, just having a friendly time. And then these mean guys did this thing to him, which was misleading. But then the state presented witnesses that said that Mr. Thomas was a gang member. This wasn't us. We didn't bring this up. That he is a gang member, that he was a gang leader. And then they brought in experts that talked about If Gang, Inglewood Family Gang, and Bird Gang. And these are the gangs that Mr. Thomas was associated with. And so all this character evidence has really come from the state's witnesses, and it's been elicited by the state. Now, regarding what Mr. Atkins just spoke of, I think we're putting the cart a little bit before the horse, because these are things that Mr. Copeland said in out-of-court statements. I am not conceding. I hope Your Honor is considering the prior argument today about whether the statements regarding what Mr. Garlington said, or Mr. Garlington's statements, alleged statements to Mr. Copeland, are even admissible. But then there's another issue. Even if they were admissible, our stance is that Mr. Copeland on the stand, and assuming he testifies consistent again, would not deny making those statements. So I don't even know why we're playing prior statements to begin with. All that being said, my recollection of the arguments were that Mr. Copeland was making references to what he knew about Mr. Thomas as, a gang leader that may have been involved in other violent acts. My recollection of the litigation of that issue was that certain defendants, and it wasn't on behalf of Mr. Stillwell, but certain defendants have argued that Mr. Copeland is responsible for the death of Mr. Thomas. And the argument, as I recall it, was that if that's the defense's theory, that Mr. Copeland's belief and understanding, you got to remember in context, Mr. Copeland, aside from all the gentlemen here, was embroiled in his side controversy with Mr. Thomas's brother, Mr. Watts, Kelvin Watts. And there was a fight a couple days beforehand at Club Crucial where Mr. Copeland's face was blooded and he was robbed, essentially.
Right.
So he had this side disagreement going on with these individuals. And my recollection of the argument was that Mr. Copeland's knowledge and belief that Mr. Thomas had a history of violence created the motive to essentially a preemptive strike. That he knew that he was in a beef, in a disagreement with dangerous people, and that goes to his motive.
Okay, he's
Mr.
not,
Copeland.
yeah, who is not alleged to have had by anybody, as far as I can tell from what y'all have said to me today, to have had involvement in Mr. Thomas's murder before the fact.
I don't No, that's not been the state's theory, and that
Okay.
has not been Mr. Stillwell's
Okay.
theory. But that did come up.
Okay, well, it may be that what Mr. Copeland thinks about Mr. Thomas's violent reputation is entirely irrelevant then.
It may be it may be irrelevant.
Okay.
I don't want to speak for other counsel, but that's my recollection
all right.
of the events. But again, I think that, in my personal opinion, the most prudent thing is to figure out which of these statements are
Right.
even going to be admissible
Sure.
first.
Yeah.
But in general, Your Honor, the defense is not, we haven't been bringing out evidence about Mr. Thomas. The state played a video where Mr. Thomas's brother was carrying an assault weapon in a barber shop at the time of the shooting. The state's witness said that Mr. Thomas.
Okay.
Your Honor,
Yes.
I wanted to briefly, if the court would permit, I found my notes just to
Okay.
give the court some examples.
Sure.
So these are from my notes, so the time hack should be pretty close. But for example, in the January 28, 2015 interview of Mr. Copeland at Atlanta Police Department headquarters, right around 7:48:13, which is the time that evidence reviewer uses, Detective Dennis asked, "What do you know about Nutt having anyone else out there?" I might have missed a word, either killed. There was some alluding to that. And Copeland, I have, says, "On Cleveland, don't know much about it. What about the boy on Auburn?" And Copeland says, "Who? Scooter?" And Detective Gaither, another APD gang detective, says, "Mr. Copeland, tell us more." You start smiling. And Copeland says, "I heard something, but was not much. It's just like he did get caught up. Somebody had him killed." So it's that kind of, in the state's opinion, speculative examples of specific conduct. And that's why in the state's brief that I know the court has reviewed these briefings, a April 2024 Supreme Court of Georgia case, Ward v. State, 318 GA 884. I used in Ward, it's dealing with kind of the outer limits when someone's claiming self-defense. I like reading Ward, one, because it's the highest court in Georgia and it's recent, but number two, not being able to use specific acts of the victim as character evidence in even a self-defense allegation, which no defendant in this case has alleged that they shot Mr. Thomas in self-defense. It still establishes it must be through reputation and opinion only. And so the state's it's a two-part motion. Specifically, character of the victim is rarely relevant in a murder trial. And two, if it is relevant, it has to be through reputation or opinion on some salient issue. And three, what Mr. Copeland's discussing about, to the state's understanding, is quite speculative even at that. But the state's position is specific bad acts, which murder, I can't think of a more concrete example of a specific bad act of a witness or a deceased victim than murder. So speculating about that, the state feels that's just classic improper under 24-4-404 and 24-4-405 alpha.
Okay. Well, I plan to follow 24-4, 404, and 405. That's
Thank you.
about as much as I can say about that right now until we get into specifics either. All right. But thank you for at least fleshing it out so I understand what we're talking about. All right. The state has a motion to compel defendants' compliance with the reciprocal discovery obligations and to exclude evidence intentionally withheld and not timely disclosed. And I had via email asked specifically as to the authorship of this particular motion and to have whomever authored this motion be present in court. The response I got back was Ms. Love saying, "I will be present." Does that mean, Ms. Love, that you are the author of this motion?
Yes, Judge.
Okay. So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell, and then the statement, quote, "A defendant has a duty," underlined, "to disclose prior to trial and an ongoing duty to timely disclose in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence, see id, meaning see the above two cases, Waddell and Young. I've read both of those cases. Show me in either of those cases where there is a proposition that discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
I didn't say solely as impeachment. I said as both impeachment and as substantive evidence
Which
of innocence.
implies that the use of it as impeachment evidence triggers the reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was
Well,
saying
you
is-
wrote it inartfully.
I did then, because what I was saying was that it has to be both. That is the representation that
All right.
I made. And then when I amended it,
I didn't see an amendment.
I have a copy for the court.
Did you fix that?
What I did was
Thank you.
sort of elaborate on it, or yes, I guess you could say it was fixed.
So you concede then that if evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
Yes, that's
Okay.
not, yes, I was not saying that. I was saying,
Good to
and
know.
my apologies to the court for that inartful wording.
Okay.
And what I said in the amendment, Your Honor, was,
Did you email the amendment to my chambers?
I did
Okay.
yesterday. I believe.
Yesterday. Okay.
Yes, it
Well, that
was.
may be why I hadn't seen it, although I've been looking at y'all's stuff nonstop.
Yes.
Okay. It's in front of me now. So
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware of what OCGA 1716-4C1 requires. And then I go down to subsection C on that same page where I cite Aggie versus the state 311 Georgia 340 at 343, and go on to say Georgia's discovery law does not explicitly apply 1716-4C to evidence used simply for the purpose of impeachment.
okay.
And then I say it unquestionably applies to that second intended purpose, use as substantive evidence. And then in section D, Your Honor, I cite to relevant similar federal laws, pointing out that federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control. Possession, custody, or control, my apologies. Where the defendant intends to use the item in the defendant's case in chief at trial. And that's Federal Rules of Criminal Procedure 16B1 alpha.
All right. So it can be used in the state's case in chief and maybe be impeachment evidence, maybe be substantive evidence, maybe be both. It's not where in the trial it comes in that matters. It's whether it's used and intended for use as substantive evidence or not.
That is,
Okay.
yes.
Okay, so as long as we're all on the same page with that, and I actually do think that to the extent anybody might want to take a closer look at what those distinctions are, I think it's Waddell,
Yes.
where the court actually says, hey, you know what, these can be tricky, these can be dicey. Here's what it means. Here's the difference between the two. So I would recommend for everybody's reading pleasure the court's exposition of that issue in the Waddell case.
And in this amendment, I did correct
All
the
right.
Waddell site.
Okay. All right, so we'll follow that law as well.
So, Your Honor,
Yeah, and so I guess I don't know if you've got specifics with regard to things that you believe have not been turned over or
I
that
do.
exist and haven't been turned over?
Well,
Okay,
I cite, for example, in these amendment to the supplement on page 1, the first example was recordings that were held by counsel for defendant Williams of an interview conducted with state's witness Adrian Bean. The evidence that was shown at trial was that Mr. Bean was a co-conspirator with defendant Williams in an intrinsic armed robbery. The state conducted days worth of direct examination of Mr. Bean, only to learn the weekend before the day cross-examination of Mr. Bean was to begin that counsel for defendant Williams had a recording of an interview he had conducted along with his investigator, which had been in counsel's possession since January of 2023. In which Bean claimed that defendant Williams was never involved in the armed robbery, and in which Bean claimed that the police told him to put defendant Williams in the crime. Mr. Williams presented this statement not just as impeachment evidence, but as substantive evidence, and further based upon information provided by Bean to the state upon information and belief. The recording that was given to the state was only a portion of the recorded statement at issue. And we do not have, if there are further statements, if there are further recordings, we don't have them. We've not been offered them. We don't know what they consisted of. Another example is defendant Williams has asserted verbally that he is in possession of a video recorded statement of the witness currently on the stand, in which that witness reportedly asserts, "We killed Nut," referring to Mr. Donovan Thomas. The state is not in possession of any such recording, is unaware of the existence of one, but as I stated earlier, Mr. Williams has asserted verbally that he has such a statement. Mr. Copeland, as I stated, is currently on the stand, and the state has not been given any such recording or been privy to or been able to review any such recording despite a specific and direct request for it. We assume that defendant Williams intends to use the recording, if one even exists, not simply for impeachment purposes, but as substantive evidence. Given these explicit and deliberate decisions to withhold material specifically that we've outlined above, and I will also point the court's attention to a similar example of with intentionally holding back material. There were jail recordings of the witness on the stand now, Mr. Copeland, that apparently defendant Williams has had in his possession for quite some time, long before Mr. Copeland took the stand. And we were only around the time that Mr. Copeland took the stand presented with these recordings. We expressed having a problem with being able to access them, and we were given another set of recordings that contained some other files that maybe were missing in the first one. But the withholding, the deliberate withholding of these items is what has prompted the state to ask the court for relief here. We are not asking the court to exclude late, disclosed discovery. That's not what we're asking for, but deliberate intentions to withhold information that a defendant intends to use both as substantive and impeachment at the same time. evidence. We are asking for the relief that we have referenced in our initial motion. And if the court is not inclined, as we've stated on page 5 of our amendment and supplement to the state's motion to compel, we recognize that both Georgia and federal authority instruct that courts employ the least extreme sanction to remedy discovery violations. If the court deems exclusion of a particular piece of evidence too extreme, the state requests that the court issue an order directing defendants to permit the state to inspect and copy any and all material that a defendant possesses, which the defendant intends to admit as substantive evidence, even if the material is also impeaching of a witness, and directing that where the proffering defendant intentionally withholds such material, that it be admitted, if at all, solely as impeachment evidence, and with a limiting instruction prohibiting the jury from considering it as substantive evidence.
All right. So with regard to the 3 things that you outlined specifically, you now have the recordings of witness Bean. Is that true?
We have one recording of witness Adrian Bean that apparently was made on an iPhone, but is, according to the information that the state received from the witness as he got off the stand, that may not reflect all of what was taken down.
What do you mean by taken down?
Well, there were, as the witness left the stand, he indicated that, and actually on the stand, he instructed Mr. Steele to keep it 100, implying that that's not everything. In other words, that what we were hearing was not everything. The recording itself was kind of degraded, and we were not, it did not appear to be one pulled directly off an iPhone the way that an iPhone would, the quality of an iPhone recording would be. And I apologize to the court, but there was one more instance. D'Angelo White was a witness that the state put on the stand, who represented to the state that that counsel for defendant Williams recorded the interview, or appeared to be recording the interview that he conducted with D'Angelo White at the Fulton County Jail. We've never received any recording of an interview between counsel for defendant Williams or anybody else conducted at the Fulton County Jail. I believe I heard earlier reference today to, I don't know if I heard that was the subject of any ex parte hearings or meetings with the court between counsel for multiple defendants and the court. But if there were or are any interviews of D'Angelo White in anyone's possession or that were made, we would believe the state to be entitled to them. He was a witness who was examined and cross-examined on the stand. So there were 4 instances.
All right. Well, he already has been examined and cross-examined.
Yes,
Okay. And no such recording was used.
right. They did not.
Okay. Then why would y'all be entitled to it?
It's just an example of something that we wouldn't, that we weren't aware of.
Okay, but y'all aren't entitled to be aware of every aspect of a defendant's
I don't
case.
disagree.
You are entitled to something that would have been a recording that then gets used as substantive evidence, but it sounds like that did not,
The court is
right?
correct.
Okay, so that one
They'll
doesn't
scratch it
matter.
off.
Okay. So Mr. Williams saying he has a video recorded statement of Mr. Copeland saying we killed Nutt, which he might want to use as substantive evidence, as well as any jail recordings of jail calls of Kenneth Copeland, I guess, with anybody, I would assume.
And we have been,
Y'all got all of those too, right?
so we have been provided, these were not jail call recordings from the Fulton County Jail. They were
Okay.
from a different, but we've been provided, according to defendant Williams, counsel for defendant Williams, we've been provided all that they have.
Okay,
And so if that is the case, then there is no further issue.
okay, that one's fine too.
Correct.
So, Mr. Steele and/or any other defense attorney, if you have recordings or statements or anything like that, that you intend to use as substantive evidence, whether it is in a case you might present later or the state's case, I think you know this, but need to disclose that to the state. Now, if it just comes up at the very end that, oh my gosh, I didn't know I was going to use this, but now I think I want to, then we might have to sort out whether that's in fact what's going on or not. But I expect everybody to abide by their discovery obligations. If I end up making a determination that somebody is willfully failing to abide by those obligations, then I will consider sanctions. But I would hope at this point, and with what I've already heard, I haven't really heard anything that I find alarming and improper. So unless anybody wants to say anything else, I'm just at this point going to say I expect y'all to abide by your discovery obligations.
And Your Honor, if I may add one more thing, I believe that counsel for defendant Williams emphatically stated he does intend to use a video recording that he has in his possession of the witness currently on the stand purportedly saying what he asserted, and that we're
Okay, well, I mean, I can see how that might be impeachment evidence, and I'll have to hear whether and how it might be substantive evidence. Mr. Steele.
May I have 1 second, Your Honor?
Sure. This is a long second, Mr. Steele.
No, hopefully it'll be worth it. Your Honor, may I approach?
Yes. Thank you.
Thank you, Your Honor. So I believe that what the state has asked you to do and what you said from the bench about the law that will apply in this case is not accurate under Georgia law.
Okay.
I also, again, I'm not going to continue to repeat. I hope that you would take it the way Judge Glanville did. I have all objections to any proffer made by District Attorney Love. They are not only wrong, but I'm going to show you why they are knowingly wrong. This is the fourth time we're having the same hearing. I know you're not here privy to this.
Okay.
What Prosecutor Love did not tell you is the Georgia law that I've already handed to them. Judge Glanville has ruled on this 3 times.
Okay.
Every time telling the state the same thing, that they're wrong. So I'll go through it for the 4th time that Ms. Love intentionally, I assume, she has a memory of this because she was here. I hand her all these cases. So I assume that she's doing it intentionally. First of all, what she has told you about the case in your reading of Waddell is not accurate. The original case that the state is using is a case from the 4th Circuit called United States versus Young. Young is what Waddell talks about.
Okay.
If this honorable court would look at United States versus Harry, which should be in your package. I may not have put this in perfect order because one of them were not stapled, but you should have the United
got it.
States. Okay, and Harry is Harry, and it is 2014 U.S. District Lexus, which is LEXIS 160233. And what happens in the Harry decision is the district court judge in New Mexico analyzed a beautiful analysis of the Young case. And that starts, Your Honor, on page 11 of 17 of the copy I've given this honorable court and the parties. And if you can turn to that page, if you don't mind,
I'm there.
on the left-hand side, the first full paragraph. And it reads, in United States versus Young, which is Y-O-U-N-G, the 4th Circuit did not explain its decision, but held only that the district court did not abuse its discretion. The holding in United States versus Young may be explained by the fact that the 4th Circuit was applying the previous version of Rule 16, which used the term evidence in chief. Unlike Judge Friedman in United States versus, and I'm just going to spell it if you don't mind, HSIA, the 4th Circuit did not define evidence in chief as case in chief. And then it goes through defining case in chief. The advisory note, I skipped 3 lines, Your Honor. The advisory notes, the advisory committee notes to the 2002 amendments state that the change from evidence in chief to case in chief may be substantive in nature. The term evidence in chief may have, as the Fourth Circuit held, encompass both the parties' case in chief as well as a party's non-impeachment cross-examinations. Even if the term evidence in chief encompassed all non-impeachment evidence, including cross-examination, this broad term does not mean that the term case in chief does as well. The Fourth Circuit in United States versus Young indicated that a party's case in chief encompasses the time in which the party calls its first witness until it rests by repeatedly using the term case in chief in that manner. So I tell you this because the Waddell case goes back to the Young case. The Young case is a federal analysis of a rule that we don't have in Georgia. In addition to that, there have been 0 circuits following United States versus Young. Georgia has never cited Waddell or Young, but Georgia speaks directly on what our law is. And there's 2 different cases, Your Honor, with the same name of Green, Green. And if you can take a look at the most recent Green case, which you should have in your package.
Yes.
And for the Honorable Court Reporter, this is going to be Green, no E at the end, and it's 368 Georgia Appeal 74. 889 Southeast 2D 190, 2023. And what the Honorable Judge Pipkin, which is Pipkin, states, and Your Honor, you could look at, if you don't mind, at this case in page 3 of 5 of the copy I've given the parties. And this Honorable Court, footnote 3 is at the bottom left. And it reads, we also agree with appellant. This case was reversed. So let me just take a step back, if I may. What happens is the state did exactly in the Green case what Ms. Love's asked you to do here. They said that the lawyer for Mr. Green had evidence for a while, didn't turn it over until the day of trial. The judge excluded because the quote, and this is a quote, sat on it too long. Therefore, the state was prejudiced and excluded the evidence. And the Court of Appeals said, you know, there was no evidence of bad faith or prejudice analysis, so we're reversing. But they dropped this footnote. And the footnote they wrote, and I'm quoting, we also agree with appellant that it is not at all clear that the defense failure to timely disclose, and I'll just tell you, but TALON note was in fact a discovery violation, given that Talent was a state's witness, COCGA section 17-16-7, requiring the production of statements concerning the testimony of witness. That, and it's in italicized, so it's stressed, the party in possession, custody, or control of the statement, and then in italics, intends to call as a witness at trial. I didn't call these witnesses. I don't intend to call these witnesses. The next line goes further, and I'll explain it if you don't mind. It's very easy to explain.
Yeah.
However, we assume, I'm just reading the footnote, for purposes of this opinion, that the note was subject to discovery, and we need not resolve the question or address any possible tension between, and then it gives the 2 code sections that we're dealing with, OCGA 17-16-4, little b as in Barry 1, and OCGA section 17-16-7. So if we look now, and I should have given this Honorable Court and the parties a copy of both code sections, OCGA section 17-16-4. If you look at that first, assuming everyone has it, and it starts for the criminally accused obligations under the Discovery Act, and Mr. Williams did, in fact, opt into discovery. And if you look at the copy I've given this Honorable Court and the parties, it starts on the very bottom of page 2, but it just says B as in Barry, but it really goes over, Your Honor, to page 3. And that's where the 1 is in 17-16-4 in the copy I've given. And it says that the defendant within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties or as ordered by the court to inspect and copy books, papers, documents, photographs, tangible objects, audio and video tapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings or places which are within the possession, control, custody, or control of the defendant. And this is what I stress, Your Honor, it's stressed in the footnote, and which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at trial. Your Honor, under OCGA section 17-16-7, if you look at that, and I've given a copy of that to this honorable court and the parties.
Mhm.
And that has, give me 1 second. That has no later than 10 days prior to trial, or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing, other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in possession, custody, or control of the state or prosecution, or in possession, custody, or control of the defendant or defendant's counsel, that relates to the subject matter concerning the testimony of the witness, that the party in possession, custody, or control of that statement, and this is what I stress, intends to call at the trial or such post-indictment pretrial evidentiary hearing. I didn't call these witnesses. So the reason that it is so important is we're just dealing with whose case in chief. Georgia doesn't have the pre-2002 Rule 16 analysis that was done in United States versus Young. This is not even close. Page 5 of 7, and Your Honor, I am now in the other green. So it is GREEN versus state, but it's 307 Georgia 171,
Mhm.
835 Southeast 2D 238. It's a 2019 case. No relation that I know of. It's in Division 4. It's on page 507, like I said. Left-hand side, the last line before the footnotes, 2 lines up, actually. It says, however, that is not what Georgia law requires. As provided by the plain language in 1716-4B2, the statute does not require a report to be prepared and made available or served unless the defendant intends to introduce in evidence the defense, I apologize, in the defense case in chief or rebuttal the results of the scientific test or experiment. If you go to the next case, which should be, or another case, I don't know if they're in order, but it's Carmichael, Your Honor,
Uh-huh.
which is CARMICHAEL versus state. 353 Georgia Appeal 64. That's 836 Southeast 2D 184, 2019 case. And Your Honor, if you can turn to, from the copy of Guinness Honorable Court and the parties, page 7 of 8. And Your Honor, this is on the left-hand side, the first full paragraph, but counting from the bottom. 9 lines up on the right. I am quoting from our court, and this is just one case. There's so many. Just before the state rested its case in chief, the trial court instructed the jury that when a stipulation is entered into the facts, as to facts of other parties, you can accept those facts as being true without further proof. My point is, their case in chief is, it's a term of art.
It has a distinct meaning.
Yes, and if you go back to the Harry case, it's actually a fascinating case to read. It's an enjoyable case to read. They go through case in chief versus evidence in chief, and they talk about specifically all the U.S. Supreme Court cases. It's on page 8 of 17 of the United States versus Harry, Your Honor. It's a well-written, it's really a good job. On the left-hand side, the first full paragraph on page 8 of 17. And the district court in New Mexico wrote, courts have repeatedly used the term case in chief to refer to the part of the trial between the time that a party calls its first witness and when it rests. And then they go through all these United States Supreme Court cases that talk about that. I mean, it's not even an issue. So I, for the fourth time in doing this, the state then has, or the court said that wants to know about Waddle. Waddle is different. Waddle specifically, and I assume that you have the case because I heard you refer to it. If not, I can get it.
I do.
So in United States versus Waddle, which is WADDELL, and it is 2016, U.S. District, which is DIC period, Lexus, LEXIS 68748. It was decided and filed on May 25, 2016 by the district court in Southern District of Georgia in the Savannah Division. Your Honor, if you go, and I'm not saying we have the same copy, so this is on I have page
Maybe what page of the slip opinion?
I'm trying, I think it's page 11 is what I'm looking at. It starts out with one
Right.
final point.
Mhm.
Okay. So the Waddell case, the judge said, no, you don't have to give it over. But if you're lying, that's, I think, I'm not saying that's.
Right,
what
right.
was in the
Now I
opinion.
read it. Yep.
Then
Mhm.
you're going to be in a lot of trouble or something
Right.
to that effect. But what happened in the issue in Waddell was they were talking about a statement given to the accused before the indictment. So it wasn't done under the auspices of work product, where the lawyer goes out and interviews witnesses. What Ms. Love tries to do is, I would have a chilling effect. I interviewed every witness that would talk to me. I interviewed everybody. And what Ms. Love is saying is, give me your work product. If I'm not going to use it the way I understand the law, unless you tell me differently, I'm not giving it to the state. So
That's my understanding as well.
So when she says, Mr. White, and I heard what you said, they didn't use it, why would you ever get it? That's exactly right. I hardly cross-examined Mr. White. But the state is telling me to give it. They went so far as Ms. Love called our investigator and tried to get involved and break the attorney camp. She told our investigator, she didn't call me, give me any recordings that you have of Mr. Bean, the investigator's skill. So he must have said, I wasn't on the phone. But Ms. Love then reported it to Judge Glanville, who said that was appropriate. He shouldn't have given you anything. Said, Mr. Steele's investigator's obstructing us. This is so wrong of the prosecution. 4 times I've given the same case. 4 times I gave that Green case. 3 times Judge Glanville ruled. In addition to that, there's factual, not only, am I rejecting? I am never taking Ms. Love's proffer. Okay, so she says that I said, I don't talk with Ms. Love, by the way, if you didn't know that. So I never said anything to her. But that I
Is there
said,
somebody on the state's case that you are able to talk to?
yeah, Ms.
Okay.
Willis.
All right. Well, okay.
On
Go ahead.
the second page, and I'm just looking at the amendment to supplement on page 2, in the center of the page.
Right.
And I should start above, but I'll get to that if you don't mind. For another example, Defendant Williams, it's me that she's talking about, has asserted verbally that he has a video recorded statement of Kenneth Copeland in which Copeland reportedly asserts we killed Nutt, referring to Donovan Thomas. Well, let me tell you how that happened. I never said that. Ms. Hilton sends an email and says, upon interviewing Kenneth Copeland, we found out that he put out a social media recording that he killed Nutt, or we killed Nutt. It's in writing. Can you please give it to us? We can't find it. The most I may have said, which I don't have a memory of saying anything, is I'm not giving you anything. If I use something, I'll use it in court. That sounds like something I would say to these prosecutors. To other people, I would say, you're going to have to, I don't have to give that to you. I'm not going to be able to talk about that. I never said, I verbally asserted that I have anything. But if I do, I'm going to say the same thing that I'd always say. I'm not giving it to them. If you tell me to do it, I'll do whatever. But I'm not going to give them anything because I don't have to. That would be impeachment. Mr. Copeland, before the 12th day of June of 2024, specifically was asked by Ms. Hilton, did you kill Nutt? And he said no. That would be impeachment. The next one that I did not give over Mr. Copeland's jail calls until recently. Let me tell you the truth. October 2023, I gave jail calls of Mr. Copeland to the state. October 2023. The state doesn't raise this until more recently when Mr. Copeland is a witness. They want me to tell them which jail calls am I going to use to impeach the man. I said, I'm not going to do it. Judge Glanville said, you don't have to do it. I'm not going to do it unless you tell me to, but I don't understand how I'm doing this. And then to stand here and say, I just gave it to him is preposterous. In addition to that, then we go to the first one, Mr. Bean. Mr. Bean testified for days. This case, Your Honor, has taken so long. I don't know how long he was on the witness stand. It would not shock me if he was there for 3-4 days. All he said was, I don't recall. That's what he said. I don't recall. Did you say this? I don't recall. I don't recall. So the state got in his prior statements to Detective Quinn. Well, I impeached him. He gave me a statement on recording. The state then doesn't ask Mr. Bean in front of the jury, doesn't ask him in front when he's here to be cross-examined. They come up with the Judge Glanville ex parte, give him some sort of document that supposedly shows Mr. Bean is scared, which I doubt. This is just me, doubt out of no evidence. And then in the middle of that document says that Brian Steele and his investigators, I'm not quoting, were in a car with Mr. Bean and his son. And Brian Steele was telling Mr. Bean what to say. And his son has that on recording. That never happened. That never happened. But what Ms. Love was allowed to say in front of the jury, believe it or not, did Mr. Steele stop and start that recording? Mr. Bean said what he always says, I don't recall. I objected, outrageous, outrageous. It just flows right through. The same way Ms. Love stands here today and says it's hard to hear, or whatever her words are, hard to decipher on an Apple iPhone. That did not happen. It is offensive. The legal analysis is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and I did the same thing without being tempered.
All right.
That's 4 times.
Thank you for clarifying that.
Your Honor, may I briefly respond?
Yeah, when Mr. Steele clears the area. Yeah, go ahead, Ms. Love.
Thank you, Judge.
Do you have any Georgia law that represents what you have asserted in your motion and amended motion?
Your Honor, that's just it. I have been clear in my amended motion, and to
Which
the
I
extent that
just
it
got a
wasn't,
copy of.
yes.
Okay.
And also, I just want to say that,
No Georgia law that.
right, Georgia law does not define, it does not define case in chief. It does
Well,
not break it
we all know
down.
what a case in chief is. I mean, don't we? I think we all know what a case in chief is. Is there any support for your assertion that reciprocal discovery is required based on the concept of substantive evidence?
Your Honor, what I have said and what I maintain is that, one, there is an absence, and I'll point the court to 3 different cases, Harris versus the state 314, Georgia 238 as one, And these are just instances,
238? What did you say?
yes.
Okay. What are
Three,
the other two and what are they going to represent?
307 Georgia, 171, which is the 2019 Green case that Mr. Steele cited for the court, and 146 Georgia App 423, which is Phillips versus the state. And
When is that from?
I'm sorry.
What year?
Just 1 second, Your Honor. That's a 78 case,
Okay, so that one's not relevant at all
old case.
because we have a new evidence code since 78. So, okay.
And Your Honor, even with respect to the older case, the only thing that I was citing Phillips for was the proposition that in the absence of specific legislative or decisional case law on the particular issue that is at hand
Mhm.
in Phillips, we commend the Federal Rules of Criminal Procedure, Rule 16, for guidance.
All
That
right,
is,
well, we've got a specific rule here now, don't we?
well, when you say we have a specific rule, is the court speaking of the discovery statute that says?
That's what we're talking about in
I
this
don't
motion, right?
Right, yes, Your Honor. We are talking about that, and the state's position, the state maintained, first of all, let me be real clear, we didn't file a brief. This is the first brief that we have filed where we've asserted these things. We have asked that the court require Mr. Steele to turn this stuff over, but we've never argued it out. Mr. Steele has stood up and said he's not required to, and he has pointed to the discovery statute. The court has said, okay, yeah, he doesn't. And we put that in our motion to the court, that the court has previously made a ruling that we thought deserved a second look at. Defendant Williams has adopted as his witnesses all the state's witnesses in the witness list that he filed. And so, Your Honor, when we assert based on Waddell, and Waddell also speaks about work product, and it makes this distinction between factual history and work product and what the state or is and is not entitled. The state stands on its assertion regarding what the requirements are because of the fact that I understand the court's position that there is no misunderstanding about what case in chief means in Georgia. But as there was this expounding on its meaning in Waddell, I think it's important to recognize that there's not been a similar sort of expounding in Georgia, and we can all presume or take for granted that it just means when the defendant
When
is
you're
putting up his
presenting your
particular case.
witnesses.
Right.
Okay, so do you have any case law
In Georgia,
in Georgia that supports the position you took in your motion that reciprocal discovery requirements are triggered based on whether you're presenting something as substantive evidence? That's my question to you.
Your Honor, the only, what we have in support of the motion is cited in the amendment and in the motion itself. We have not ever presented or represented to the court that there was a Georgia case that addressed this issue, and the conclusion that is asserted in the state's filings are the result of the fact that, one, from our position, it's not addressed directly, that, what case in chief specifically.
So you are telling me that when our discovery statute says that the defendant is to produce or permit inspection and copying of whatever it is that they're in possession or control of, which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at the trial, you think that there's some kind of lack of clarity about what that means? Is that what you're representing to the court?
Your Honor, I'm representing that was the position that was taken. That was what was analyzed in the cases that we have cited in our amended amendment and supplement to our motion to compel. That is, in our position, a reasonable interpretation. And as I don't as we've said in our filing, Your Honor, there was the requirement in Waddell that anything that was within the defendant's possession, custody, or control, where the defendant intended to use the item in the defendant's case in chief, that be turned over. The Waddell Court, Your Honor, in analyzing the meaning and understanding of case in chief, as the court correctly pointed out earlier, said that if it is going to be used as both impeachment and substantive evidence, that constitutes case in chief. From there, we made the assertion, the state's position, that if the defense intends, because there's nothing in Georgia law that analyzes it at this level, if the defense intends to introduce evidence as both impeachment and substantive evidence, then they have a duty to disclose it. And that is the origin of the state. That is.
If you knew this was your last, best chance to protect all the places you love, what would you do?
About,
As I have said
What
in my
that means.
motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute. He said we do not. I have never asserted, I've never made this distinction. I've never said that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that argument in a written or oral filing.
okay. All right, well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms.
Your Honor,
Love.
respectfully, I take it very seriously.
Okay, so anyway, we'll be abiding by the discovery requirements set forth in our statutes. And Mr. Steele, thank you for the clarification. All right, I think that brings us to the issue of when we first met, Mr. Short had suggested that there might be, well, I don't know if it was Mr. Short or Ms. Love, honestly, one or the other of you. We discussed the possibility that there might be outstanding discovery that maybe actually was required to be produced that either was missing or just hadn't been talked about. And I wanted us to kind of go through in detail what it is that everybody thinks maybe the other side has that they're entitled to that they haven't gotten yet. So are we in a position to be able to do that now? If not, we can do it tomorrow or the next day and we can move on to, we've got other stuff to do too. Which exhibits have actually been admitted, if that's an easier one for this afternoon? Which would y'all rather? We've got to do them both, so I don't really care which order we take them in.
Speaking for the majority on this side of the room, we'd ask if we could take that up tomorrow.
Okay, so can we do then today? I think Mr. Steele provided a sort of as a starting point, a list or a chart or a spreadsheet or something of his understanding of what exhibits have actually been admitted. And for us to take this pause is a good time to make sure we're all on the same page about that. And I know that Ms. Weaver, the court reporter, had at least provided to me, but I don't know whether she copied y'all or not, a couple of places based on that chart where she thought she wanted some clarification, or she thought maybe it had been talked about but not actually admitted, so we can go through all of those. Do y'all have that, or do I need to get y'all that?
Your Honor, we have that, I believe that might be a rough draft. We have been keeping, a list as well. And we
Okay.
have been referencing, the recorded proceedings to ensure that we are accurately keeping note of what has been and hasn't been
All right.
admitted. As I stated earlier, there have been instances where it has been proper that evidence has been admitted, it has been tendered.
Right.
That has not been the case. So we are still, and we would ask that the court allow us to get a little bit further along in checking all of these exhibits.
All right, so,
What has really and truly been admitted.
so the question was, do y'all have the kind of response from Ms. Weaver about her take on a couple of discrepancies? Okay. Ms. Percival, could you share that with everybody? And I was hoping that we could do this today. The state is not ready to yet. You know, I want to try to take us to the end of the day because we have a lot of work to do. Maybe there's something else that we still need to cover that we could cover today.
Judge, we are going through each piece of evidence, and we are comparing our record
Okay.
with the actual physical piece of evidence that we have submitted or the defendant has submitted. So that endeavor is
I'm sure it's time consuming, voluminous.
and we have endeavored to make certain that it's accurate. So
Well, that'll be helpful. We would want that. All right. So, Ms. Percival will email out to y'all all the couple of comments that Ms. Weaver, in her looking back, believes might be inaccurate on the chart that Mr. Steele has put together and shared with everybody. So y'all can take a look at that. We can deal with it tomorrow. I know one thing that we're going to need to sort out. Ms. Weaver had mentioned that there are times when, and I think she said it was, I don't know who, but somebody on the defense side, or maybe more than one person on the defense side. I don't know if the state's doing it as well or not, but you will approach a witness with a laptop and show them something on the laptop and ask them about it. And that it is difficult for the court reporter to then sort out what was that exhibit actually. And I don't know if anything has been admitted that way, but I do know that the prior judge, there is an administrative order filed in April in this case that requires all evidence offered by any counsel be submitted to the court in physical form and marked as appropriate at the time of its admission for it to be properly made a part of the record, and directing counsel to provide physical copies to the official court reporter, who now obviously is no longer Ms. Weaver for going forward. It is going to be our new court reporter, Ms. Winfrey. But we actually need, electronic copies too, but we need something that is physical, whether it's on a jump drive or a flash drive, or whether it's a piece of paper. There's no way for the court reporter to capture sort of, I guess, a screenshot, unless y'all take a screenshot of the screen that you're showing the witness and then give that piece of paper or electronic file to the court reporter. That would be fine, but there has to be something that represents whatever you showed the witness on the screen, okay? Does everybody understand? Anybody have any questions about that? Okay. So we can take up tomorrow, after y'all have had a chance to look at it, the couple of issues that Miss Weaver's got a different record than what Mr. Steele does. And then I would love for y'all to be able to get together on if there's no discrepancy, then we don't have to worry about it if everybody's on the same page. But you know, if there is a discrepancy, if y'all don't talk to each other, maybe you could just email each other. Here's where we think there might be a question or an issue so that we all know before we talk about it, what it is that we need to talk about. So can y'all do that this evening? Don't ever, thank you. Okay. All right, very good. All right, the state has provided an updated witness list, which is still fairly long. And I would like to know from the state, does that list include, is that just the witnesses that have been called yet that still need to be called, or does that include everybody, the witnesses who have been called and those who are still to be called?
Your Honor, that includes the witnesses that need to be called. Some have already been called, but
Yeah.
those are everyone moving
Yeah, there
forward.
were a few you highlighted and said we may recall these. So that is 105 or so witnesses still to go. Though.
Yes.
Okay. And is that with y'all narrowing it down and picking only the witnesses y'all need?
Yes.
Okay. Well, we'll see. But, all right, are there any other, you know, we've got to figure out how we're going to deal with Mr. Copeland's sort of redo, but are there any other motions that I haven't gotten to yet today or mentioned today that are outstanding?
I emailed Your Honor's chambers regarding motions that I filed in, because I did not have access to Odyssey and I could not pull them off the internet, and I did not have the file copies on my computer. I identified what they were, but they were noted, essentially, I would think they're titled notices of objection. They were regarding, Your Honor may or may not know this, there was a wiretap in this case. There's, and then also my client's phone, actually 2 phones, were extracted and dumped. So there's numerous phone calls, texts, emails, things of that nature that are on either the wiretap that were intercepted, some involving some with my client as a part of those communications, some not, as well as all the things that are typically on a cell phone that deal with someone's essential life on an electronic device. The state has, to my knowledge, not identified what they plan to use from either of those sources of information at this time. And that's why I labeled it a notice, because there is irrelevant information, there is prejudicial information, there's on the wiretap, not so much Mr. Stillwell, but there's other individuals on these wiretaps discussing all sorts of other acts that have nothing to do with this case. And so there's just a lot there, and we're going to need to have that discussion at some time.
Okay, thank you. When does the state intend to let the defense know what it is they're actually using out of the universe of all possible things?
Your Honor, what I think that we have represented to the court previously is that prior to, I believe we had said at least a week before, because there is a large volume, to say the least, of calls within the jail calls and within the wiretap that are that have been turned over in discovery. And I believe that we had previously said that did we say the week before? 2 weeks before we intend to use them, we would apprise defendants of which ones.
Can y'all explain to me how you are dealing with a large volume of what ought to be motions in limine while in the midst of trial. And still being in any way efficient with the jury's time, you're not, essentially. Okay. All right. That's just not practical. I mean, we're going to change that going forward. And I'm not going to say I need you to know everything tomorrow because I know it's a voluminous case, but y'all been putting this case together for 2 years. And you ought to know, I mean, you clearly know what witnesses you're going to be using, and you've given me, you know, kind of a very broad idea of what exhibits you intend to use with those witnesses. But I don't know that if we're just every other week saying, okay, let's figure out all of the evidentiary issues that have to do with the next 2 weeks worth of witnesses. We can do that in one day on a Friday. We just can't. So we're not going to be able, I mean, we all know that we've got this week, and we know that the jury has already been told before I became involved that they essentially have the week of, what is it, August 19th out. So, you know, this week might be taken up pretty much with sorting out the 2 things I just mentioned, and then sorting out all of the evidence that goes along with Mr. Copeland, because he's our next witness up. But the week of August 19th, we need to be plowing through a whole lot of other evidence, not just what's coming up in the next 2 weeks. We need to be covering the next several months, which ought to be, frankly, the end of this trial by then. I mean, it should not take another 7 months. It shouldn't. Whether it does or not, I don't know. But so the state needs to produce in much more detail a much more winnowed down but comprehensive list of what the evidence they intend to use with each witness is going to be, so that the defense can see it, evaluate it, make whatever evidentiary objections they have to it, and the court can have some time to view the evidence, listen to the evidence, whatever the evidence is, and evaluate the evidentiary issues, so that we know by the time the witness gets on the stand, here's what is coming in. I mean, for the most part, it's a trial, but what's coming in and what has already been excluded. So do I need to be more explicit about that? Or do y'all understand your marching orders?
Yes, we understand what the court is asking.
All right. So like, I feel like I need to be more explicit about it, even though I know y'all understand. By the beginning of next week, I want to see, you know, at least the next 30 witnesses worth of evidence, okay? And then maybe by the end of that week, the next 30. Okay? All right, and we're going to plan to be here all of the 19th, and I don't know when else we're taking breaks, but okay, so that's that.
Can I ask a clarifying question, Your Honor?
Yes.
And Mr. Adams and I, Attorney Adams and I filed, I think that motion, it was not helpful just to say like witness Kenneth Copeland, jail calls, social media. I think you just covered that though.
Well, and you know, in fairness to the state, I do think that when I asked them for that, I said kind of broadly, let me know what evidence. And now I'm asking for it in more detail, just because practically speaking, in the middle of a trial, we've got to sort out what evidence is admissible, and ideally not while the jury's sitting there waiting on us.
That's perfect.
Okay.
We appreciate it. The specifics will make us roll better anyway.
Yeah.
Thank you.
All right. So any other motions that are still needing to be addressed? And y'all, it's 3:30 and I plan for us to do work until 5:30 and we can take a little break, but I'd really like for us to figure out something that we can make some progress on for the next 2 hours. So let's take a 10-minute break, be back, well, it's 3:34, be back at 3:45. And y'all think in the meantime, all right, what can we use this time productively to do? Thanks.
All right, y'all. We'll be back. Choke no joke. I got videos dropping. You know what it is. Thanks for tuning in. We'll be back.